Open the court, Mr Tipstaff.
All persons having business before this honourable court are commanded to give their attendance and they shall be heard. God save the Queen. Be seated, please.
Call the matters.
Commonwealth Director of Public Prosecutions in Bessem and Commonwealth Director of Public Prosecutions in MHK for mention.
At the outset, the parties are reminded that a suppression order was made by this court on 9 June 2017 in the matter of the Commonwealth Director and MHK, prohibiting the publication of any details or image which tend to identify the respondent MHK, his family or anyone connected with them. The parties in both proceedings, as called, the parties requested to appear, the media and all present should be mindful of the order. Throughout the hearing this morning, the respondent in the Commonwealth Director and MHK should be referred to as that, the respondent or MHK. It should also be noted that the hearing this morning is being recorded in accordance with the Court of Appeal's streaming practice direction. The purpose of convening the mention in both cases this morning arises from publications in the media relating to the Commonwealth Director and Bessem expressly and inferentially Commonwealth Director and MHK. On 9 June 2017, the Court of Appeal, as presently constituted, heard appeals against sentence by the Commonwealth Director in both cases of Bessem and MHK. During the course of oral submissions and argument by counsel for the parties, members of the bench in the ordinary course asked questions, made comment and engaged in discussion with counsel. The appeals were conducted in the standard way that thousands of appeals have been conducted in this appellate court and other appellate courts across Australia and around the common law world for hundreds of years. At the end of submissions, the court reserved its judgment in each of the cases. On 13 June 2017, the Australian published an article, Judiciary, Light on Terrorism, directly relating to the Commonwealth Director and Bessem. The article attributed statements to the Honourable Greg Hunt MP, the Minister for Health, the Honourable Michael Sukkar MP, the Assistant Treasurer, and the Honourable Alan Tudge MP, the Minister for Human Services. The attributed statements were published whilst the judgments of the Court of Appeal were reserved. Given that the Court's decisions in both cases were pending, the Court was concerned that the attributed statements were impermissible at law and improperly made in an attempt to influence the Court in its decision or decisions. Further, the Court was concerned that some of the statements were calculated to improperly undermine public confidence in the administration of justice in this state in respect of the disposition of the appeals that the Court has presently under consideration. The Court was further concerned that the attributed statements were made by 3 ministers of the Crown. The statements on their face failed to respect the doctrine of separation of powers, breach the principle of sub judice, and reflect a lack of proper understanding of the importance to our democracy of the independence of the judiciary from the political arms of government. Arising from the Court's concerns, letters were sent by the Judicial Registrar of the Court of Appeal to the Honourable the Attorney-General of the Commonwealth of Australia with respect to the 3 ministers and the publisher and editor of The Australian and the journalist with respect to the article. The letter informed those parties of the Court's concerns and gave notice that the Court required the individuals or their legal representatives' appearance before this Court today to make any submissions as to why they should not be referred for prosecution for contempt. Copies of the letters were provided to the parties in both the Bessem and MHK matters. We note the parties are present in court. In a moment, appearances will be taken. We note that there is no inter-party status of the ministers and what I will call the newspaper interest. Their attendance is informal and at the request of the court. Before taking appearances, the publication in question makes it necessary in the circumstances to say the following in the strongest terms. The parties in both cases, on both sides, namely the Director, Bessam and MHK, should comprehend that this court has not been and will not be affected by the statements at all made in the Australian article or elsewhere in the media. Those parties should be assured and confident that nothing that has been said in the article or about the article can have an effect on the decision or decisions the court will make. We particularly emphasise to the public that it should be assured and have the utmost confidence that the court will decide these matters independently, impartially and in accordance with the rule of law. Notwithstanding that the article and associated commentary have not been and will not impact on our decision-making process or any decision itself, the public should understand that that is not the end of the matter. There are important principles of law that arise when anyone speaks about a court's decision or its conduct during a hearing before the decision is delivered. We would add, in the strongest terms, the legal notions of contempt of court do not exist to protect judges or their personal reputations. These laws exist to protect the independence of the judiciary in making decisions that bind governments and citizens alike. These laws further exist to protect public confidence in the judiciary. This morning is not an occasion to debate whether the court's concerns are justified at law. That is, it is not to debate whether contempt has been committed. That may be for another court to determine. Rather, it is an opportunity for those involved to inform the court of any relevant matters they wish before we determine whether to refer the publication for prosecution for contempt of court. We will now take appearances.